The Declaration of Separate and Equal Station, a treatise on the history of the corrupt money system of the corporate United States. The document below is an exact copy of the original document Mr. John Nelson wrote on February 21st, 1992, with the following exceptions. 1. Many statements have been made bold or italicized to emphasize their importance. The original document had neither bold nor italic text. To the American people, the people of the state of Colorado, USA, February 21st, 1992, Declaration of Cause and Necessity to Abolish and Declaration of Separate and Equal Station. I suggest you read Senate Report number 93, 549, 93rd Congress, First Session, 1973. Summary of Emergency Power Statutes consisting of 607 pages, which I believe you will find most interesting. The United States went bankrupt in 1933 and was declared so by President Roosevelt by Executive Order 6073, 6102, 6111, and by Executive Order 6260 on March 9, 1933. See Senate Report 93, 549, pages 187 and 594. Under the Trading with the Enemy Act, 65th Congress, Session 1, Chapters 105, 106, October 5th, 1917, and as codified at Title 12 USCA 95A, which has been repealed. And when they say repealed, they don't mean that it's been abolished, they just mean they repealed it somewhere else. So they peeled it from one page and stuck it somewhere else. So, for example, Title 12 USCA 95A, Title 12 being banking, was now moved to Title 50 4305B2, Title 50 being the military code. So you can find Title 50 4305B2. It was formerly Title 12 USCA 95A. All right. Now, I'm going to point out a little later on that these titles are not the law. All right. And I'll show you where you can actually find the law, because these titles so often subvert from the factual basis and premise of the law by ad-libbing or deducting words or subtracting from the meaning. So often the titles do not actually follow what was said on the congressional floor, on the congressional record, okay? So again, Title 12, USCA, so that's United States Code Annotated 95A, has in fact been repealed, which means it's been peeled from Title 12, which is the banking code, and moved under Title 50, 403, 405, excuse me, Title 50, 403, Title 50, 403B2, 405B2. So anyway, I had it right the first time. On May 23rd, 1933, Congressman Louis T. McFadden, who's a motherfucking hero, I don't care what anybody has to say about this guy is a hero, brought formal charges against the Board of Governors of the Federal Reserve Bank System, the Comptroller of the Currency, and the Secretary of the United States Treasury for criminal acts. It wasn't until after he had sadly passed that they agreed with him. Very quietly, it was just a small blip in the paper, and they moved forward. The petition for articles of impeachment was thereafter referred to the Judiciary Committee and has yet to be acted upon. See Congressional Records, page 4055 through 4058. Congress confirmed the bankruptcy on June 5th, 1933, and impaired the obligations and considerations of contracts through the joint resolution to suspend the gold standard and abrogate the gold clause June 5th, 1933. House Joint Resolution 192 is nothing more than a resolution. It's no different than when you made a resolution this year to go to the gym every day or every other day and then you failed to do so. It was just a resolution. And when you decided it was no longer important, you could back out of it. The same thing with Congress. Unfortunately for Congress, 48 statute 112 is still there. And it's verbatim House Joint Resolution 192, 73rd Congress, first session, okay? So the important thing to glean from this section right here, ladies and gentlemen, they treat you like a raccoon. They want you to pay attention to the shiny shit, all right? The gold and the abrogation of the gold clause. Okay, let me tell you something. The abrogation of the gold clause isn't, it pales in comparison to what they really did. Because June 5th, 1933, they mortgaged everything. So it wasn't just the abrogation of the gold. They mortgaged it all. Your contracts, your labor, the blades of grass in front of your house, real estate, property, fixtures, movable and immovable, general tangible and general intangible. They mortgaged everything. See House Joint Resolution 192, 73rd Congress, first session. The several states of the Union pledged the faith and credit thereof to aid of the national social security, to aid the national government, and formed numerous socialist communities. Socialist being socialism, that's what they cast us into, such as Council of State Governments, Social Security Administration, etc. To purportedly deal with the economic emergencies, these organizations operated under the Declaration of Interdependence of January 22nd, 1937, and published some of their activities in the Book of the State or States. The 1937 edition of the Book of the States openly declared that the people engaged in such activities as the farming, husbandry, industry, and had been reduced to mere feudal tenants on their land. Book of the States, 1937, page 155. Now, this is exactly what the founding fathers were fighting. They were tired of feudalism. They wanted to be able to own their land and not have to worry about being kicked off the land because the king didn't get his warm apple pie that morning, right? Or maybe he just didn't like the way you looked at him. So he said, your family's been on that land, that parcel of land, but that land is mine, and you were just a feudal tenant, so I can kick you off anytime I see fit, right? So it's important to understand what happened was so egregious that the founding fathers would have loaded up their muskets, and there would have been governors, politicians of the like swinging from trees over this deal, all right? This, of course, was compounded by such activities as price fixing of wheat and grains, Title VII USCA 1332, quota regulations, Title VII USCA 1371, and livestock products, Title VII USCA 1903, Blogmaster noted repealed, which have been consistently below the cost of production, interest on loans, and inflation of the paper bills of credit, leaving the food producers and others in a state and thereby a condition of abject peonage. All right, slavery, bondage, and peonage are illegal. Involuntary servitude are also unlawful, and involuntary servitude constituting the taking of private property for the benefit and use of others without just compensation. Now, that's a violation of the Fourth Amendment, ladies and gentlemen. You have a right to be compensated justly for your property if the government intends to use it for their benefit. And that's just what they did when they abrogated the gold, put a mortgage on everything. It was under the guise so they could do international business because they were default and bankrupt. And so something naturally had to be pledged. And ladies and gentlemen, what was pledged should mortify you. And through usufruct, these people have gotten away with this for quite some time by taking over the public fool system and making sure that you're highly uneducated to be able to handle your affairs as a grown-ass man or woman and to hold these people accountable. Note, the Council of State Governments has now been absorbed into such things as the National Conference of Commissioners on Uniform State Laws, whose headquarters office is located at 676 North Street, Clare Street, Suite 1700, Chicago, Illinois, 6611. And of course, Chicago, Illinois is where the Bar Association really got their foot in the door. I believe it was in 1906 is when they fired that up. And then shortly thereafter, all the other states agreed, and they created their own private institution for justice that's monopolized. And all being members of the bar, surprise, surprise, and operating under a different constitution and bylaws. All right, so For everybody that's familiar with a constitution, it's nothing more than a charter, and the very definition of the word constitutor is to roll debt from one entity to another. So, in the Act of 1871, when they reconstituted everything because they were again default and defunct and bankrupt, they created new constitutions. They didn't really differ much from the organic constitutions, except for the fact that the way that they used dog Latin, if you will, or all capital letters, which altered and changed the document and its intent. Far distant from the depositories of the public records, has promulgated, lobbied for, passed, adjudicated, and ordered the implementation and execution of their purported uniform and model acts and pretended statutory provisions to help implement international treaties of the United States, or where world uniformity would be desired. A one world government under the United Nations, ladies and gentlemen. See 1990-91 reference book, National Council of Commission on Uniform State Laws, page 2. This is apparently what Robert Bork meant when he wrote, "We are governed not by law or elected representatives, but by an unelected, unrepresentative, unaccountable committee of lawyers applying no will but their own. The Tempting of America, Robert H. Bork, page 130. This association has been engaged in activities such as turning marriage licensed into international private law through its international liaisons, which meet at such place as the Hague Conference. See Handbook of Commissioners on Uniform State Laws, 1966 edition, page 156 through 157. On April 25, 1938, the Supreme Court overturned the standing precedent of the prior 150 years concerning common law in the federal government. There is no federal common law, and Congress has no power to declare substantive rules of common law applicable in a state, whether they be local or general in their nature, be they commercial law or a part of the law of torts. See Erie Railroad Co. versus Tompkins, 304 U.S. 6482 L period ED period 1188. The common law is the fountain source of substantive and remedial rights, if not our personal right to inalienable liberty. See Stephen A. Treatise on the Principles of Pleadings, Introduction, page 23, and Hemingway, History of Common Law Pleadings, as evidence of the growth of individual liberty and power of the courts. 5 Alabama Law, Journal 1, Swift versus Tyson, 16 Peters 1, 10 L period ED period 865, Constitution, Article 3, Section 2, Amendments 7, 15, and 10. The members and association of the bar thereafter formed committees, granted themselves special privileges, immunities, and franchises, and held meetings concerning the judicial procedures, and further to amend laws to conform to a trend of judicial decisions or to accomplish similar objectives, including hodgepodging the jurisdiction of law and equity together, which is known today as one form of action. See Constitution and Bylaws, Article 3, Sections 3.3c, 1990 through 91, reference book, Supra. See also Colorado Methods of Practice, West Publishing, Volume 4, pages 2 and 3, author's comments. Note, the enumerated, specified, and distinct jurisdiction established by the ordained Constitution, 1789, Article 3, Section 2, and under the Bill of Rights, 1791, Amendment 7, were further hodgepodged and fundamentally changed in 1982 to include admiralty jurisdiction, maritime admiralty, which was once again brought inland. This is the fundamental change necessary to effect unification of civil and admiralty procedures. just as the 1938 rules abolished the distinction between actions at law and suits in equity. This change would abolish the distinction between civil actions and suits in admiralty. Federal Rules of Civil Procedure, 1982 edition, page 17. Also see Federalist Papers number 83, Declaration of Resolves of the First Continental Congress, October 14th, 1774, Declaration of Cause and Necessity of Taking Up Arms, July 6, 1775, Declaration of Independence, July 4th, 1776, Bennett versus Butterworth, 52 U.S. 669. The United States thereafter entered the Second World War, during which time the League of Nations was reinstituted under pretenses of the United Nation. All right? See sections 22 USCA 287 ETSEQ and the Bank for International Settlement, reinstituted under pretenses of the Bretton Woods Agreement. See 60 Statute Large 1401, Title 22, United States Code Annotated 286 ETSEQ as the International Monetary Fund. The fund and the International Bank for Reconstruction and Development, the bank, the United States as a corporate body politic artifice, came out of World War II in worse economic shape than when it entered, and in 1950 declared bankruptcy and reorganization. The reorganization is located in Title V of the United States Code Annotated. The explanation at the beginning of Title V USC Annotated is most informative reading. The Secretary of Treasury was appointed as a receiver in bankruptcy. See Reorganization Plan number 26, Title V, USCA 903, Public Law 94-564, Legislative History, page 5967. The United States went down the road and periodically filed for further reorganization. Things and situations worsened. Having done what they were commanded not to do, see Madison's Notes, Constitutional Convention, August 16, 1787, Federalist Papers number 44, and in 1965 passed the Coinage Act of 1965, completely debasing the constitutional coin, gold and silver, i.e. dollar. See Title 18, United States Code Annotated 331, 332, United States versus Marigold, Title 50, USC 560, 13, L period ED period 257. In other words, they engaged in mixed war against the Constitution and the people and the Union of States to overthrow the government. At the signing of the Coinage Act on July 23, 1965, then President Lyndon B. Johnson, traitor, piece of shit, rat bastard, weasel, should have been hung by his testicles until he couldn't fucking breathe anymore, stated in his press release that, "When I have signed this bill before me, we will have made the first fundamental change in our coinage in 173 years. The Coinage Act of 1965 supersedes the Act of 1792. Well, this couldn't be further from the truth because, again, acts do not amend the Constitution, ladies and gentlemen. They may have created their own little fucking fallacy and fictional land that they live in, but it did not abolish nor amend the organic Constitution, all right? And that act had the title, An Act Establishing a Mint and Regulating the Coinage of the United States. Now, I will sign this bill to make the first change in our coinage system since the 18th century. To those members of Congress who are here on this historic occasion, I want to assure you that if the people should ever figure out what the fuck we're doing, we will all surely die." That's not what it says, but it's what it should have said. I want to assure you that in making this change from the 18th century, we have no idea of returning to it. It is important to take cognizance of the fact that no constitutional amendment was ever obtained to fundamentally change, amend, abridge, or abolish the constitutional mandates, provisions, or prohibitions, but due to internal and external diversions surrounding the Vietnam War, etc., the usurpation and usufruct and breach went basically unchallenged and unnoticed by the general public at large, who became a wealthy wealthy man's cannon fodder or cheap source of slave labor. All right. See Silent Weapons for Quiet Wars, TM-SW7905.1, pages 6, 7, 8, 9, 12, 13, and 56. Congress was clearly delegated the power and authority to regulate and maintain the true and inherent value of the coin within the scope and purview of Article 1, Section 8, Clause 5 and 6, and Article 1, Section 10, Clause 1 of the ordained Constitution, ordained meaning granted by God, blessed by the Heavenly Father, 1787, and further, under the corresponding duty and obligation to maintain said gold and silver coin and foreign coin at and within the necessary and proper equal weights and measures. And they're telling you that you need to pay $275 or whatever it is. Ask them what those dollars weigh. How much do those dollars weigh? And I bet they can't tell you, because they couldn't. Not with the fictitious monetary system they're utilizing now, which is nothing more than double bookkeeping entries and credits manifest on existence onto a record. That's all they are. Credits on account. That's it. Nothing more, nothing less. See also Bible, Deuteronomy, chapter 25, verse 13 through 16, Proverbs, chapter 16, verse 11, Public Law 97-289, 96 Statute at Large, 1211. Those exercising the office of the several states in equal measure knew such de facto transitions were unlawful and unauthorized, but sanctioned, implemented, and forced to complete the botchment and the resulting governmental, social, industrial, economic change in the de jure state and in the United States of America. See Public Law 94-564, Legislative History, pages 5,936, 5,945, 31, Title 31, United States Code Annotated 314, Title 31, United States Code Annotated 321, United States Code, Title 31, USC Annotated 5112, CRS 11-61-101, and CRS 39-22-103.5, and CRS 18-11-203, and were and are now under the delusion that they can do both directly and indirectly what they were absolutely prohibited from doing. See also Federalist Papers number 44, Craig versus Missouri, 4 Peters 903. In 1966, Congress, being severally compromised, passed the Federal Tax Lien Act of 1966, by which the entire taxing and monetary system, i.e. essential engine, see Federalist Paper number 31, was placed under the Uniform Commercial Code, see Public Law 89-719. Legislative History, pages 3,722, also see CRS 5-1-106. The Uniform Commercial Code was, of course, promulgated by the National Conference of Commissioners on Uniform State Laws in collusion with American Law Institute for the Banking and Business Interest. See Handbook of the National Conference of Commissioners on Uniform State Laws, 1966, edition pages 152 and 153. The United States, being engaged in numerous United Nations conflicts, including the Korean and the Vietnam conflict, which were under direction of the United Nations, see Title 22, United States Code Annotated 287D, and agreeing to foot the bill, see Title 22, United States Annotated 287J, and not being able to honor their obligations and rehypothecated debt credit only, and publicly dishonored and disavowed their notes and obligations, see Title 12, United States Code Annotated 411, which means redeem unlawful money, Federal Reserve notes, through Public Law 90-269, Sections 282, Statute at Large 50, 1968, to wit, Sections 2, the first sentence of Section 15 of the Federal Reserve Act, Title 12, United States Code 391, is amended by striking at and the funds provided in this act for the redemption of Federal Reserve notes, see Title 22, United States Code Annotated 287, ETSEQ. Things steadily grew worse, and on March 28, 1970, the then President Nixon, another swine, issued proclamation number 3972 declaring an emergency because the postal employees struck against the de facto government for higher pay due to inflation of the paper bills of credit. See Senate Report number 93-549, pages 596. Nixon placed the U.S. Postal Department under the control of the Department of Defense. This is a very important piece because in times of military occupation, everything falls underneath the military, the DOD, the Department of Defense, and Federal Reserve notes are actually script issued by the DOD or approved by the Department of Defense. All right. In times of war and military occupation, all minerals, all rights, everything is absorbed wholly by the occupying force. See Department of the Army Field Manual, FM 41-10, 1969 edition. The system had been faltering for a decade, but the benchmark date of the collapse is put at August 15, 1971. On this day, the then President Nixon, scallywag, reversed U.S. international monetary policy by officially declaring the convertibility of U.S. dollars, the Federal Reserve Note, FRN, into gold. See Public Law 94-564, Legislative History, pages 5,937, and Senate Report number 93-549. Forward, page 3, Proclamation number 4074, page 597, and Title 31, United States Code Annotated 314, and Title 31, United States Code Annotated 5112. On September 21st, 1973, Congress passed Public Law 93-110, amending the Brentwood's Par Value Modification Act at Statute at Large 116, Title 31, United States Code Annotated 449, and reiterated the emergency. Title 12, USCA 95A, which has been removed to Title 50, 4305B2, all right, underneath the military. And Section 8 of the Brentwoods Agreement Act of 1945, Title 22, United States Code Annotated 286F, and which included reports on foreign currency transactions. Also see Executive Order 133, it's actually 10,033. This act further declared in Section 2B that no provision of any law in effect on the date of enactment of this act, and no rule, regulation, or order under the authority of any such law may be construed to prohibit any person from purchasing, holding, selling, or otherwise dealing with gold, because it would violate Article 1, Section 10, which prohibits the government from interfering with contract, the obligation of contract. On January 19, 1976, Majority S. Holt noted for the record a second declaration of interdependence and clearly identified the United Nations as a communist organization, and that they were seeking both production and monetary control over the Union and people through international organizations, prompting the One World Order or One World Government. See Congressional Record, January 19, 1976, extensions of remarks. Also see Title 8, United States Code Annotated 1101-40, Title 50, United States Code Annotated 781 and 783. The Cisco economic situation worsened as noted in the complaint petition filed in the United States Court of Claims, docket number 4176 on February 11, 1976, by 44 federal judges. This is very important, ladies and gentlemen. When these 44 federal judges realized they were getting the shaft in the old ass and the old kisser without any lube, and somebody was hitting them in the bunghole with a cactus, they were a little pissed off. So 44 federal judges filed suit. Atkins et al. Versus United States. Atkins et al. Complained that as a result of inflation, the compensation of federal judges has been substantially diminished each year since 1969. Ladies and gentlemen, the reason they're bringing this to everybody's attention is because the day a fiat currency is created, from its very inception, that is the most value it will ever have as it's introduced to the system and everybody begins to use it. From that point on, History has shown us for tens of thousands of years that a fiat currency by design is designed to implode, which means through stagflation, inflation, deflation, by manipulating the monetary system through bookkeeping entries, so on and so forth. Eventually, it's worth nothing. Like your current Federal Reserve note is worth nothing today because now the Saudi Arabians are selling their barrels of oil with dinar and other promises of currency. So the Federal Reserve note is no more. It's worthless. You can't wipe your ass with it. It's not worth starting on fire. A goat burns hotter, to be honest, and why would you waste your good, precious time, valued commodity and energy to burn dollars when you could burn goat turds and they burn hotter, longer, and faster, all right? Causing direct and continuing monetary harm to plaintiff. The real value of the dollar Federal Reserve note decreased by approximately 34.5% from March 15, 1969 to October 1st, 1975. Now, these guys didn't want to take it in the shorts. They realized that by saving Federal Reserve notes or credits on account or bank account, you're not saving anything. You're actually losing your equity because it's depreciating in value, ladies and gentlemen. These are very, very, very prominent legal scholars, all right? And I talk bad about the great majority of them because they're fucking assholes, okay? They're fucking people over, and as long as they're riding high on the hog, be damned the rest of the people. Yet they want to proclaim that you're part of their society. And it couldn't be further from the truth. As a result, plaintiffs have suffered an unconstitutional deprivation of earnings. Ooh, how many of you have fallen subject to that? How many of you proclaim to use Treasavant versus the city of Tampa Bay? And here are the 44 illustrious chancellors, judges, administrators telling you that it depreciated by 34.5% from March 15th, 1969 to October 1st, 1975. Are you still wanting to use Treasavant's case in 1984? How much do you think that Federal Reserve note has depreciated since 1984 with Treasavant versus the city of Tampa Bay? All right. As a result, plaintiffs have suffered an unconstitutional deprivation of earnings, and in the prayer for relief, claimed damages for constitutional violations enumerated above, measured as the diminution of his earnings for the entire period since March 9th, 1969. It is quite, and this is why the consumer price index comes into play. You know, this is what these 44 illustrious chancellors, if you will, and I don't know if they were illustrious or not. The older they are, they seem to have made better decisions in the past, so we'll give them the benefit of the doubt. But what they're doing is they're saying, hey, we're going to go back because our precious valued time commodity has not decreased in value, and we're going to use the consumer price index to get back what rightfully is owed to us due to the depreciation of the Federal Reserve note at a whopping 34.5% from March 15th, 1969 to October 1st, 1975, and it was awarded to them. But they were all put underneath that non-disclosure agreement. You're going to go ahead and we'll make this right with you, but for the rest of the vagrant peasants that fall underneath our control, since we're now feudalism or subjected to feudalism and feudal tenets, well, we're never going to tell them the truth, and you're going to rule the way that the bankers wish you to rule, and that way we don't have any problems. It is quite apparent that the person holding and enjoying office of public trust, okay, it's a trust. They tell you this everywhere, guys. So I always ask them, do you disclaim the trust? It's like asking them if they still beat their wife. It's a double-edged sword. If you answer no, well, then you admit that you used to beat your wife. And if you say, I refuse to answer, then you're still beating your wife. Either way, you're fucked. Honor and or profit knew of the emergent problem and sought protection for themselves. For themselves. Oh, how noble and honorable these people were. Not for the American people. Not to say that what is happening and transpiring is wrong, but so long as you make it okay for us, and we use the consumer price index and go back and rectify our loss, the American people be damned. to the damage and injury of the people and children who were classified as a club that has many other members who have no remedy. And knowing that heinous acts had been committed, stated that they, judges, lawyers, would not apply the law, nor would any substantive remedy be applied, checked more or less, but never stopped, until all of us judges are dead. Such persons fraudulently swore an oath to uphold, defend, and preserve the sovereignty of the nation and several Republican states of the Union, but nevertheless intentionally breached that duty to protect the people, citizens, and their posterity from fraud, imposition, avarice, and stealthy encroachment. See Atkins et al. Versus U.S. 556, F period 2D 1028, pages 1072, 1074, The Tempting of America, Supra, pages 155, 159. Also see Title 5, United States Code, annotated 5305 and 5335, Senate Report number 93549, pages 69 through 71, and CRS 24-75-101. This is verified in Public Law 94, 564, Legislative History, pages 5944, which states, moving to the floating exchange rate for international commerce means private enterprise and not central governments bear the risk of currency fluctuations. Numerous serious debates were held in Congress, including but not limited to Tuesday, July 27, 1976. See Congressional Record, House July 27, 1976, concerning the international financial institution and its operation. Representative Ron Paul, chairman of the House Banking Committee, made numerous references to the true practice of the international financial institutions, including but not limited to the conversion of 27 million in gold contributed by the United States as part of its quota obligation, which the International Monetary Fund, Governor, Secretary of the Treasury, sold. See Public Law 94-564, Legislative History, page 5945 and 5946, under some very questionable terms and concessions. Also see Ron Paul, Money Book 1991 by Ron Paul, Plantation Publishing, 837 West Plantation, Clute, Texas, 77531, on October 28, 1977, the passage of the Public Law 95-147, 91 Stat 1227 declared most banking institutions, including state banks, to be under direction and control of the corporate governor and of the International Monetary Fund. See Public Law 94-564, Legislative History, page 5942, United States Government Manual 1990-91, pages 480 through 481. The Act further declared that Section 10A of the Gold Reserve Act of 1934, Title 31, United States Code, annotated 822A, now Title 22, United States Code 286E, is amended by striking out the phrase stabilizing the exchange value of the dollar. C, the joint resolution entitled Joint Resolution to Assure Uniform Value to the Coins and Currency of the United States, approved June 5, 1933, Title 31, United States Code, annotated 463, now 5118, shall not apply to the obligation issued on or after the date of enactment of this section. The international organization, corporations, and associations had refused to pay their debts and could not pay their debts, and determined that they could pass the loss of their non-redeemable, non-current notes, bonds, and evidence of debt off on others, and thereby crown their fraud with success. See letter October 26, 1989, the Department of Treasury, Russell L. Monk, Assistant General Counsel, International Affairs, as recorded in the Office of Clerk and recorded Baca County, Colorado, at Book 540, pages 364. The de facto United States as corporator, Title 22, United States Code Annotated 286E ETSEQ and State CRS, Colorado Revised Statutes CRS, by the way, 24-36-104 CRS 24-60 103.5, Westfall versus Braley, 10 Ohio 188, 75 AMDC 509, Adams versus Richardson's 337 S period W period 2D 911, Ward versus Smith 7 Wall 447. In 1980, Congress passed, among other things, Public Law 96-221, providing for the furtherance and expansion of the profligate rehypotheticated debt pyramid scheme and reduce the reserve requirements on transaction accounts to a minimum of 3% to the maximum of 14%. See Depository Institution Deregulation and Monetary Control Act of 1980, Sections 103BE2. In the United States, neither paper currency nor deposits have value as commodities intrinsically. A dollar bill is just a piece of paper. A dollar will only exchange for a dollar. Deposits are merely book entries. Coins do have some intrinsic value as metal, but generally far less than their face amount. Compare this with the United States Constitution, which says no state shall make anything but gold or silver coin a tender in payment of a debt, and which also says Congress shall have the power to coin money and regulate the value thereof. Italics added for emphasis. This paragraph added to the original John B. Nelson document of February 21st, 1992 on July 18th, 1999 to reiterate what was stated previously in the documents and to demonstrate firsthand yet another way the Constitution is being usurped in fact and intent. In the absence of legal reserve requirements, banks can build up deposits by increasing loans and investments so long as they keep enough currency on hand to redeem whatever amount the holders of deposits want to convert into currency. This unique attribute of the banking business was discovered several centuries ago. At one time, bankers were merely middlemen. They made profit by accepting gold and coins brought to them for safekeeping and lending them to borrowers. But they soon found that the receipts they issued to depositors were being used as money, since whoever held them could go to the bank and exchange them for metallic money. Then bankers discovered that they could make loans merely by giving borrowers their promise to pay bank notes. In this way, banks began to create money. More notes could be issued than the gold and coin on hand because only a portion of the notes outstanding would be presented for payment at any one time. Enough metallic money had to be kept on hand, of course, to redeem whatever volume of notes was presented for payment. Transactions deposits are the modern counterpart of bank notes. It was a small step from printing notes to making book entries to the credit of the borrowers, which the borrowers in turn could spend by writing checks, thereby printing their own money. See Modern Money Mechanics, a workbook on deposits, currency, and bank reserves, 1982, revised edition, Federal Reserve Bank of Chicago, P.O. Box 834, Chicago, Illinois, 60690, pages 3 and 4. 74 years. 74 years is not temporary. It's a permanent state of emergency and was clearly instituted, formed, and erected without the Union through gross usurpation, abridgments, malfeasance, and breach of legal and fiduciary duties, and the continual contrivance, misrepresentation, conversion, fluctuations, fraud, and artifices or schemes of the international financial institution, organizations, corporations, and associations, including the Federal Reserve, their physical and depository agents. Title 22, United States Code Annotated 286D. This prolificated practice has led to such emergency legislation as the Public Debt Limit Balanced Budget and Emergency Deficit Control Act of 1985. Public Law 99-177, etc. The government, by becoming a corporation, see Title 22 United States Code Annotated 286E, lays down its sovereignty and takes on that of a private citizen. It can exercise no power which is not derived from the corporate charter. See the Bank of the United States versus Planters Bank of Georgia, 6L period ED 9 Wheat 244, United States versus Burr. The real party in interest is not the de jure United States of America or a state, but the bank and the fund. Title 22 United States Code Annotated 286 ETSEQ and Colorado Revised Statute 11-60-103. The acts committed under fraud, force, and seizure are many times done under letters of marque and reprisal, which is staunchly forbidden under the 10th Amendment. Recapture, see Title 31 United States Code Annotated 5323. Such principles as fraud and justice never dwell together. Wingate's maximum 680, and a right of action cannot arise out of a fraud. Broom's maxims 297, 729. Culper's report 343. 5 Scott's new report 558. 10 Massachusetts 276, 38 Fed 800 are too high of a thought concept, as is due process, just compensation, and justice itself. Honor is earned by honesty and integrity, not under false and fraudulent pretenses. Nor will the color of the cloth one wears cover up the usurpation, lies, trickery, deceit, and the outright furtherance of the fraud. When black is fraudulently declared to be white, not all will live in darkness. As astutely observed by Will Rogers, there are men running governments who shouldn't be allowed to play with matches, and is as applicable today as Jesus' statement about lawyers. The contrived emergency has created numerous abuses and usurpations and abridgments of delegated power and authority. As stated in Senate Report 93549, since March 9, 1933, the United States has been in a state of declared national emergency. In fact, there are now, in effect, 4 presidential proclamations, states of national emergencies. In addition to the national emergencies declared by President Roosevelt in 1933, there are also national emergencies proclaimed by President Truman on December 16, 1950, during the Korean conflict, and the states of national emergencies declared by President Nixon on March 23, 1970, and August 15, 1971. These proclamations give force to 470 provisions of federal law. These hundreds of statutes delegate to the president extraordinary powers ordinarily exercised by the Congress, which affect the lives of American citizens in a host of all-encompassing manners. This vast range of powers taken together confer enough authority to rule the country without reference to normal constitutional process. Under the powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communications, regulate the operation of private enterprise, restrict travel, and, in the plethora of particular ways, control the lives of all American citizens. See Forward, pages 3. The introduction on page 1 begins with a phenomenal declaration to wit, a majority of the people of the United States have lived all of their lives under emergency rule for 40 years. Freedom and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by the state of national emergency. According to the research done in the 16th Am Jurisprudence 2D edition, Section 71 and 82, no emergency justifies a violation of any constitutional provisions, arguendo supremacy clause and separation of powers. It is clearly admitted in Senate Report number 93549 that abridgment has in fact occurred. The statements heard in the federal and state tribunals on numerous occasions that constitutional arguments are immaterial, frivolous, etc., is based upon the concealment, furtherance, and compounding of the frauds and emergencies created and sustained by the expatriated aliens of the United Nations and its organizations, corporations, and associations. See Letter Insight Magazine, February 18, 1991, page 7. Lowell L. Flanders, President, United Nations Staff Union, New York. Title 8, United States Code, annotated 1481, is one of the controlling statutes on expatriation, as is Title 22, United States Code, annotated 611, 612, and 613, and Title 50, United States annotated 781. The Internal Revenue Service entered into a service agreement with the U.S. Treasury Department. See Public Law 94564, Legislative History, pages 59 67, Reorganization Plan number 26, and the Agency for International Development, pursuant to Treasury Delegation Order number 91. The Agency for International Development is an international paramilitary operation. Department of the Army Field Manual 1969, FM 41-10, pages 1 through 4, sections 1 through 7b, and 1 through 6, sections 1 through 10, 7c1, 20, and Title 22, United States Code, annotated 284, and includes such activities as assumptions of full or partial executive, legislative, and judicial authority over a country or area. See Army Field Manual 41-10, pages 1 through 7, sections 110, 7c4. Also see Agreement between the United Nations and the United States of America regarding the headquarters of the United Nations, sections 7d and 8, Title 22, United States Code, annotated 287, 1979 edition, at pages 241. It is to be further observed that the agreement regarding headquarters district of the United Nations was not agreed to. See Congressional Record, Senate, December 13, 1967, Mr. Thurmond, and is illegally in the country in the first instance. The international organization's intents, purposes, and activities include complete control of public finance, i.e., control, supervision, and audit of indigenous physical resources, budget practices, taxation, expenditures of public funds, currency issues, and banking agencies and affiliates. See Army Field Manual 4110, pages 2 through 30 through 2 through 31, sections 251, public finance. This, of course, complies with the Silent Weapons for Quiet Wars Research Technical Manual TM-SW7905.1, which discloses the declaration of war upon the American people. See pages 3 and 7. Monetary control by the internationalists through information, etc., solicited and collected by the Internal Revenue Service. See TM-SW7905.1, pages 48. Also see Title 22, United States Code, annotated 286F, and Executive Order number 10,033, Title 26, United States Code, annotated 6103K4, and who is operating and enforcing the seditious international program. See Trade Manual SW7905.1, page 52. The 1985 edition of the Department of Army Field Manual, FM 41-10, further describes the international civil affairs operation at pages 3 through 6. It is admitted to the AID is autonomous, and under direction of the International Development Cooperative Agencies, and at page 3 through 8, that the operation is paramilitary. The international organization's interest and purpose was to promote, implement, and enforce a dictatorship over finance in the United States. See Senate Report number 93549, pages 186. It appears from the documentary evidence that the Internal Revenue Service agents, etc., are agents of a foreign principal within the meaning of and intent of the Foreign Agents Registration Act of 1938 as amended in 1939. They are directed and controlled by the corporate governor of the fund, aka Secretary of the Treasury, see Public Law 94564 Super, pages 5942, United States Government Manual 1990 through 91, pages 480 and 481, Title 26 United States Code annotated 7701A11, Treasury Delegation Order number 150-10, and the Corporate Governor of the Bank, Title 22 United States Code annotated 286 and 286A, acting as information service employees, Title 22 United States Code annotated 611C2, and have been and do now solicit, collect, disperse, or dispense contributions, tax pecuniary contributions, Black's Law Dictionary, 5th edition, loans, money, or other things of value for or in interest of such foreign principal, Title 22 United States Annotated Code 611C3, and they entered into agreement with a foreign principal pursuant to the Treasury Delegation Order number 91, i.e., the Agency for International Development, Title 22 United States Annotated Code, and that is the corruptible history of American finance over the past 90 plus years and the slippery slope of foreign manipulation and intervention by international banking interests who by their premeditated contrivances have disassembled and subverted our constitutional protections of the guarantee to protect and preserve the honest and substantive money of the American people, bringing upon our American shores, in derogation of our common law, the statutes merchants law of admiralty process, and thereby secretly move our country and its people under the baggage of peonage imposed by the law merchant, who by encroaching judicial precedent established an ever-expanding condition of perpetual involuntary bankruptcy and the endless generational economic bondage of the wage slave. Note, Congress was clearly delegated the power and authority to regulate and maintain the true and inherent value of the coin within the scope and purview of Article 1, Section 8, Clause 5 and 6, and Article 1, Section 10, Clause 1 of the ordained Constitution 1787, and further under a corresponding duty and obligation to maintain said gold and silver coin and foreign coin at and within the necessary and proper equal weights and measures clause. See also Bible, Deuteronomy chapter 25 verses 13 through 16, Proverbs chapter 16 verses 11, Public Law 97-289, 96 Statute at Large 1211. He who does not freely speak the truth is a betrayer of the truth. He who does not blame approves. He who is silent appears to consent. He who does not speak the truth freely is a traitor to the truth. Damage suffered by consent is not a cause of action. Thank you for joining me, and I hope this helped you guys out. Again, scroll to the top here. This is the Declaration of Separate and Equal Station, a treatise on the history of the corrupt money system of the corporate United States. Thanks for joining me, and we'll talk to you soon.